Judges cannot stand that certain Aquaman starlet's counsel, and this document in front of you, oh, it is the holy grail of them getting wrecked. This is why they had to, in fact, come off of charitable contributions. They didn't just lose the argument. The judge got sick of them making the argument. The judge slams them, ignores them. I mean, they own them completely. You and I, we're going to talk about that today. Oh, fun times, huh? Fun times indeed. So, hey there to all you fine folks on this fine day, by the way. I hope you are doing excellently. And you know things are going bad when you make an argument like this. This is her team saying to the judge, this is the reason we don't think we should have to turn things over. Basically, they weren't gentle enough about things. We could have thought of less intrusive methods, and look at the judge lose their cool about this. This is the argument. This is her team. I understand, Your Honor. So we're going to bring up two things. One, again, while these are not relevant to the proceedings, the point of what the court has raised is, well, there's been no motion to address these issues. There are less intrusive ways to obtain this information. This is what the judge is going to get mad about, by the way, this sentence right here. And as counsel included in their opposition, they have requested such via written discovery in this matter. That was objected to in Virginia. They have not. Plaintiff has not sought any relief of the court in Virginia, specifically attempting to circumvent that court by, and right here, the judge, they've had enough of this argument. And look, they butt right into it. Let me stop you for a moment. So you're saying that in Virginia court, that certain Aquaman starlet has objected to providing any evidence similar to what's being requested here? Is that what you're saying? And her counsel says, yes, Your Honor. Now, here's where the judge gets really frustrated. So what? I don't understand what the point that there are less intrusive means. Your client is objecting to the less intrusive means of just giving the information herself. And that's true, by the way. She could have just turned over information herself. You wouldn't have had to do anything like subpoenaing a place. But nope, couldn't have that at all. Had to go forward like this. In fact, there doesn't have to even be a document request. Oftentimes, I have cases where counsel just say, here, let us give you the documents as opposed to bothering the Children's Hospital. She will give you her communications with the Children's Hospital about the donation itself, a copy of the check, any emails about it she had with the Children's Hospital. Here you go. Let's not bother the Children's Hospital. We're going to just give that to you instead. I don't see anything in the papers where she has agreed to do that, either by formal discovery or non-formal discovery. So what is the less intrusive means? You know, again, they're saying, where is that? I mean, that would be the easiest thing to do. What exactly are you talking about? You're saying they have to move to compel in Virginia and go that right. Is that what you're saying? That's what it says to the counsel. Yes, Your Honor. Okay, well, I don't agree. That tone remains throughout the entirety of this conversation, too, to the point the judge just starts talking over her counsel at one point. I mean, it's pretty amazing. Look at this right here. So here's the judge speaking. The statements that are reflected in news articles submitted by JD's counsel, I don't see in any of your briefings that she's denying that at some point she made public statements that divorce proceedings were going to be used for donations to children's hospitals, right? I mean, she's not denying that, is she? And her counsel says, Your Honor, we're not denying. And look, they get cut off right away. The court says, I just want the answer, right? That's a no, right? You're not denying it, right? We have not denied it in the papers, correct? Okay, so I don't know why the court cannot consider those newspaper articles as, I believe, in one of the documents filed by JD's counsel, they believe I can take judicial notice of those documents under, they give the specific subsection in law, because the accuracy of those sources could be reasonably determined at some point, and she's not denying she said it. Well, Your Honor, we don't believe that a newspaper article is a subject of judicial notice. Well, the court continues, tell me why, under this specific subsection, that JD's counsel is seeking judicial notice. That is correct, right, JD's counsel? Yes, and to be clear, Your Honor, we're seeking judicial notice of those not for the truth of the statement made in them, but simply that they were made, basically. That's what they're going to say here. That statement was made. We're not asking the court to take judicial notice of the facts presented, but rather the documents and their existence. So the court says, okay. So do you want to respond to that, to our counsel here, in light of what he just highlighted for the court? Yes, Your Honor. They're exactly being offered the truth of the matter. I mean, there's no way to get around that. And the court just jumps in and cuts them right off. Well, let me stop you for a minute. I'm not going to look at those reports to say that she has in fact reported what she's done, but your client is not denying that she, in the news media, she's made statements about donations to the Children's Hospital for the settlement, right? And what JD's counsel is saying is that these news reports and the media reports of these statements that your client made in the public media about her divorce, her relations with JD, and donations, I'm not taking judicial notice of whether or not she was accosted, I'm going to use that word there, or she did make the donation or even divorced. It's just that they're wanting me to take judicial notice that there were media reports about this subject. And you see, her counsel tries to kick in again. But Your Honor, exactly what you said, that you are taking judicial notice of them in order to determine whether or not she made these charitable contributions. And Your Honor, well, the court cut in again. So let's put that aside then. Let's put it aside about the judicial notice. The bottom line is she's not denying in the public media. She's made statements about, in conjunction and together, she made statements about the divorce, being accosted by JD, and the donations to the Children's Hospital, all in the same statement. Their client has not, in the motion here, stated and denied, I never made those statements about JD, the divorce, charitable contributions as represented by JD's counsel in opposition to the motion. So let's say I put aside the judicial notice. Just put it aside here. She's not denying that I said I was accosted, JD and I are divorced, and to help others in my situation, I'm going to be donating charitable contributions. And so, one of the reasons why I'm inclined to deny the motion, this is where they're trying to kill this, by the way, not let JD look at that, is because that is what I believe JD's counsel has sufficiently shown as a basis for allowing the subpoena to go forward. It would be one thing if she, number one, never made any statement about charitable donations to the Children's Hospital. If she never made a public statement, your motion, it may have been granted. It may also have been granted if she had made a statement about making donations, but didn't make it in conjunction with discussions about accosting and JD and the divorce from JD. And her counsel goes to speak up again, and Your Honor, and they get cut off. I think one of my main concerns is that what JD's counsel argues is that your client has, in the public domain, made statements about JD, negative statements about JD, statements about him getting divorced from JD because of, treatment I received from him. And as a result of all of that, I'm going to be donating monies to the Children's Hospital. I don't want to keep the money. I'm going to be donating it, and I want to help other people. Now, I'm not saying these documents are going to be admissible for trial, but you haven't shown me that the court has granted any motion or made any formal ruling that any of the evidence is going to be excluded at trial. You haven't given me that to show. And while the court may have made some reference to it or maybe made some suggestion about it, as of now, again, as argued by JD, there has not been a formal order by the court that it's going to be excluded, and as part of the discovery, I think it's discoverable. Maybe there's nothing there. Maybe there is. I don't know, but I think in light of the limitations I've talked about, I think it's reasonable. They go to speak up again, Your Honor, and they promptly get cut off. There's been no formal objection by the Children's Hospital. So this is what I'm going to do. I'm going to allow JD's counsel to talk about this. I'm going to allow them to basically make a speech. You're going to get to speak. And guess how that turns out? It turns out the same way. This is how they end up losing the argument about charitable donations. They've tried every court, every judge, they've pushed them to their brink, and that's why you see the thing that you see in front of you, because judges are sick and tired of them. They know they are hiding evidence. They didn't want this stuff to come out because they knew it looked terrible. All of it does. It gets wrecked so easily. But yeah, I wanted to show you real time why judges don't like them. This is just one of dozens of examples I've found. But let me know what you think about it. I thought it was pretty funny. Like I said, it's the holy grail because you can see real time judges getting sick and tired of them. But let me know what you think about that. Check out our links in the description. That's really how you can back the channel. We have merchandising. We have our comic book, of course. We have so much more. But you being here, that is the biggest help of all. Thank you. Appreciate you. End it here. See you soon.